the followers of a particular posting that are an association?
No, we don't submit that all the users of Open Media in this case are an association. We submit that the facts of this case are actually very specific on that point. And perhaps if I turn to that freedom of association argument now and return to proportionality later, it's our submission based on the US Supreme Court and European jurisprudence that an individual has a right to associate which encompasses their individual right to anonymity in the fact of their membership, their identity, and their actions within the membership. And that has been both breached and chilled by the law and the measure. Next, there is this collective right, which I'm coming to now in response to your question, Your Excellency. And there is a collective right to associate towards a common goal. And that has been called by an article of Myung Kim, The Right to Anonymous Association in Cyberspace, enclave deliberation. They're forming a discrete niche to discuss an unpopular view. Now, in our submission, the facts that makes the MLM forum a specific association is that it forms a discrete network of individuals who have all set their posts to private. And that, in our submission, separates them from perhaps the rest of Open Media because they've circled the wagons, to use United States terminology, Your Excellency, and they've created a positive impression that they regard themselves as a separate and discrete club and an association. Now, it is our submission that the authority of NAACP in Alabama has allowed that where there is a lawful objective, and we have already submitted that that is discussion of perhaps the MLM, separatism, Mondahi liberation, where there is a history of harassment. And my co-agent has already submitted how in paragraph 16 and 17 there have been allegations of torture, kidnapping, armed gangs of Duryans attacking Mondahis, that this is reasonable. And then finally, that their rights have been substantially abridged. And if I can turn to that last part in proportionality, and my proportionality arguments here address both privacy and freedom of association. Your Excellencies, Mr. President, this law creates a permanent provision which actually contemplates 24-hour surveillance, not in the sense that someone is watching 24 hours, but in the sense that the computers are always waiting, like vultures, for whenever someone should actually happen to post. Furthermore, there is no sunset clause to this legislation or to the government's action. It's indefinite. And in our submission, that abridges the policy established, the principle established in the Sunday Times in UK case and others, which is that you have to have something tailored to the objective, or it has to be the least restrictive measure possible. And for example, alternatives could have been adopted, and we suggest that alternatives could have included a warrant system to target targets. Now, I apprehend that someone might ask, how can you have a warrant system if you can't see anyone in the forum first? Well, an example of an alternate piece of legislation would be this, and this is one example. Assuming we have failed on our arguments so far and we've reached this stage, what the government could have done differently is actually used relation and link analysis to look at the traffic within the forum. And this is raised by an article by Catherine Strandberg, which is entitled Surveillance of Emergent Associations for a Network Society. Plenty of information can be derived through this method. And then people could have been targeted. The movers and the shakers, the leaders of the forum could have been targeted, perhaps in conjunction with other surveillance. So it's in our submission here, and I adopt the submissions of my co-agent as regards safeguards, that this is too broad a brush, too indefinite, and further there's an aspect of bad faith. In the case of the military tracker surveillance, that actually took the people they wanted to surveil off a watch list. In this case, the government has spun around in the dark, seen maybe a slightly brighter light over here and taken a shot because of the topic of the forum. And in our submission, that is disproportionate.
I have a question for you.
Yes,
I certainly understand your point about the significant speech interests when you're talking about political speech, dialogue about what the military is doing. But is there really a significant speech interest in simply listing the location of where troops are?
Thank you, Your Excellency. That relates really to the First Order and the Military Tracker Forum. I am submitting on the MLM Forum. Would you like me to return to the First Order to discuss
well,
the significant...
we don't know what's in the MLM Forum, do we?
Yes, Mr. Excellency.
So to the extent that one of the requests here goes to location information, right? to the extent that this was limited to requests about location information, people who were posting about location information, would that be narrowly tailored? Would that satisfy you, because that wouldn't incur upon significant political speech interests?
Your Excellency, if I understand your question, are you requesting whether just looking at someone's location and reporting on their location in the forum is okay? Or are you saying if they're just talking about the movements of the military in the forum, is that a protectable form of speech?
Yes, the latter.
The latter. Your Excellency, it's our submission they're not talking about the movement of the military in that MLM forum. It's our submission that they're addressing a topic which is actually protected under many United Nations treaties and by state practice, that is of self-determination, separatism, and the actions of the MLM toward that goal. The discussion of the military in our submission occurs on the military tracker, and this would be one other point which would actually form the disjunction between the MLM forum on the one hand and what's occurring on the military tracker on the other. There is actually no link between the people posting on those two forums, none at all on the facts. There could be people posting on both, there could be people posting on one or neither. There is no evidence of that. So it's our submission what is occurring within the MLM forum on the basis of the topic and the purpose of Open Media is discussion about the MLM, separatism and self-determination, laudable goals under United Nations edicts.
If your argument proceeds on the footing that without conceding the fact that the MLM identity on your site is not the MLM that is contemplated in para 6, then the inferences which flow are that why isn't, could you not ask a reasonable question as to, is it a squatting? And could not be a displacement of the argument that it is not a militant site, and avoid the whole question of, is it a secret club? Why is that purposive look onto the name not being initiated by Open Media?
Your Excellency, if I understand your question is, well, we can still draw an inference from the name that they may be forming a secret club. Yeah. My submission is this: if you were going to form a secret club, why would you name yourself MLM?
No, for identification of people to reach out and be co-conspirators. You could be under serious risk of being treated as a co-conspirator yourself, as an intermediary, if you had knowledge that it is MLM and it is engaged in terrorist activity or support to terrorism. You could be an abettor. So why would you not do that?
Thank you, Your Excellency. And in my submission, this forum appears empty. So if anyone had done that, they would become visible in that forum. So on our submission, on the facts, that is not occurring. Whilst that may be one inference available on the facts, we submit that there is just simply no evidence to submit that it's occurring here. Because they've actually formed a private and secret alignment of the wagons, it's actually not possible for someone who maybe wanted to join this organisation, even assuming it was a terrorist organisation. It's a private club in our submission, and they're discussing a very important issue. Your Excellency, I would love to address your question further, but I note I am running short of time and I must move to the fourth order. Turning to the fourth order, which is...
Can I just ask you a question which will impact on what you're saying? Just so that I'm clear, one of the requirements is to report the location of the members of MLM. And do you see that as an abuse of their right to privacy or of their right to association, their location only?
With regards to privacy, their location is a breach. With regards to association, we submit that it is a breach of their individual rights to anonymity and association, and that it is a chill or an effect, what is called in NAACP in Alabama, an effective restraint on the collective right and association.
Okay,
so the
thanks.
answer,
I thought you might say that, so I'd like you to address why it's not a breach of right of privacy for the location of the first family, which you're going to come on to now.
Thank you, Your Excellency, and I'll turn straight to that right now, which is that prohibiting the publication of photographs or location information on Carla's, Dahlia's and Talia's tracker forums, and then ordering the deletion of all content on these forums does not strike a correct balance between privacy on the one hand and freedom of expression on the other. Your Excellencies, we note here the breach is not really in dispute. We accede that there has been some infringement on privacy, and the respondent have acceded that there has been some restriction of freedom of expression. But this moves again to your point, Judge Endicott. What the test we submit here is that of striking a fair balance between, on the one hand, the community's interest in a topic of general interest, which we submit are Carla and the children, their public figure status, the breadth of the measures, and also the fact of alternatives compared against the privacy and possibly the security concerns. To establish this, I'll be making two submissions. My first submission is that it does not pursue a legitimate aim, and my second...
It does not what? Can you repeat that?
My first submission is that the First Family Privacy Act does not pursue a legitimate aim. And my second is that the government has struck a fair balance between privacy concerns and freedom of expression. Mr. President, Your Excellencies, I note my time is fast expiring, so I may have to rely upon my written submissions to establish my first submission, and I will now turn directly to proportionality. Your Excellencies, what we have here is a broad blanket measure in terms of a law, and then a direct action ordering the deletion. And I'll address both in terms of their severity. This law prevents the publication in all media, and not just on the website of Open Media. Also, this 90-day requirement has actually been used rather sneakily in our submission, within the executive action to justify the removal of all content, because logically, when most of that content was posted, it was not posted above 90 days. So in our submission, this is actually not only seriously impeding the media in performing its role of communicating issues of public interest and impeded the public's right to receive issues of public interest, it's also deleted all history. It's deleted the baby with the bathwater. In our submission, turning then to the action, we submit that less restrictive measures could have been adopted. For example, we submit that only the children could have been protected because in our submission, the children and Carla are in different positions. We submit that the government could have requested geolocation tags of a high level of specificity. The Ushahidi platform is free open software, it can be modified, and we would submit that this sort of more general geolocation tag could have been requested by the government, and this would have solved all personal security and all privacy problems. Finally, there should have been exceptions for public appearances at the very least in our submission. Your Excellencies, in the very little time I have left, I must stack up the interests on either side. In our submission, Carla and the children are both public figures who generate public interest, and compared to that, in our submission, the privacy breaches against Carla were very minor. The children are in a different category, we have already agreed, but we submit that all of the photos taken of Carla and the children occurred in public, and that is a weighing factor in this circumstance. We also submit that Carla has become a politicised figure by her relationship with Vislio, and this is in relation to the case law of Kahavara, Flinkila in Finland, and Tamar in Estonia. And that raises, Your Excellencies, I note my time is expired. May I have an extension to summarise?
You can have 1 minute.
Thank you, Mr. President. Mr. President, Your Excellencies, I'll now turn to summarise our case. In summary, this case charts the use of the internet for democratic participation and then its abuse for government repression. Your Excellencies, we submit that the first part of the case focused on anonymity and data protection, and to protect these two principles, we ask the court uphold those orders. Your Excellencies, in regard to the second part of the case, we submit that that related to political participation and the ability to hold and nurture a dissenting view, and in the case of the fourth order, to hear about issues of genuine public interest. The case is so important because it gives this court the opportunity to recognise privacy, freedom of association and freedom of expression on the internet, and to protect its relevance, to protect the future of these rights, and ultimately to protect the future of the whole world. If there are no further questions, that concludes that.
I have one, if Mr. President allows me. I'm a bit lost here, because on one side you're saying everyone else deserves the right to privacy, but on the other hand you're saying the first family do not, just because of who their family are. Can you actually take us back there and tell us your particular perspective on it? Because I know we didn't have much time, but I would like to be a little more clear on your argument in terms of them being public figures.
Mr. President, may I crave an extension to answer that question?
You can answer the question.
Thank you, Mr. President. Your Excellency, your
Let's
question...
put a sunset on that, I think. Just
Your Excellency, the question you ask, as I understand it, is what is the difference between users of the MLM forum and their privacy rights, and then Carla and her children's privacy rights on the other hand? Now that imports two separate questions. First of all, we submit that Carla and the children are public figures, whereas the people in the forum are not. And in our submission, the case law in Europe is that, and also in the United States, in cases like Robert Gertz and Robert Welsh, and also in Europe in cases like Flinkila and Finland, is that public figures must accept a higher level of interference. Now, it's our submission that Carla's privacy rights can be breached in this case because she's an important social figure, and Resolution 1165 in Europe suggests that can be a source of public figurdom. She is also deriving political and capital importance from Visleo, and this is through the cases of Flinkila, Kahavara and Tamer in Estonia. Finally, she has actually met a public figure, a politician, and an economic figure of importance in a context where there is political unrest, ethnic tensions, and also grumbling about the tax overhaul and reform. So not only has she, a public figure herself, got a lesser right, I beg your pardon, withdraw that, has to accept higher interference with her privacy.
Do you have a legal precedent to support that?
Which aspect of that, Your Excellency?
Her meeting a public figure, or the timing of, about the fact that she was meeting a public figure at the timing of war, or etc.
Your Excellency, we would not accept that there is actually a war on foot here, in essence, Your Excellency, we would rely on the case of Flinkila and Finland. And in that case, in the context of an affair, one of the considerations which, and the court's language was backlit its decision, was that essentially a mistress of a politician engaged in a public argument outside the home of that politician, and he was married. So the importance of the politician and the fact that she had voluntarily put herself into that situation actually cooperated to increase the level of interference she must accept.
Thank you very much.
May it please the court.
Yes, please come forward. Yes.
A very good afternoon, Your Excellencies. This is Agent Number 1, Kunal Singh, on behalf of the respondent, the Republic of Bamida, in this matter between Open Bamida and the Republic of Bamida. I will be taking up 20 minutes of this court's time, my co-agent Mr. Sourav a further 22 minutes, and we will be reserving 3 minutes for Sir rebuttals, Your Excellency. Now, I believe that Your Excellencies are well versed with the facts of this case, and the jurisdiction of this chamber is undisputed, and hence I seek permission to move directly to the issues raised by the applicants, Your Excellency. Now, primarily, Your Excellencies, 3 challenges have been made by my learned friends for the applicants. They've challenged the Internet Responsibility Act on grounds of freedom of speech and expression. 2, they've challenged the IRA on grounds of a violation of right to privacy. And lastly, they've challenged the First Family Privacy Act on grounds of violation of a right to freedom of speech and expression. Now, I will be responding to them on the first challenge, and my co-agent will be responding to them on the other 2 challenges, Your Excellencies. If Your Excellencies have no queries with regard to the division, I seek permission to move on to my submissions, Your Excellencies. I request Your Excellencies to please turn to page numerical 1 of our memoranda, Your Excellencies.